This is Dr. David Shine, and welcome to Business Law 101. Now, keep in mind that the assignee stands in the shoes of the assignor, which means if there's something they're required to do, they're required to do that because the original obligor was required to do it. Or if it's a benefit, then they stand in line to receive that benefit. In most cases, it's going to be a two-way street. They need to do their share, and they need to get the performance back in return. Now, keep in mind that unless the other side agrees to the assignment, the assignor remains liable as basically the surety for the assignee if the assignee fails to perform. And one of the other things is that the assignee can demand performance unless they have failed to give notice. And this is a very serious problem that happens sometimes in sales. So Joe sells his boarding house, and he's got 4 tenants in there. Each tenant has a lease or a contract with him for 1 room in the boarding house. So he doesn't tell the tenants in the boarding house that he sold the property. So what happens is the tenants keep paying the seller because the seller never told them to start paying the new owner. And so this is something that's very important, and a good transaction will make sure that there's an assignment of leases and deposits done as part of the sale transaction. That's the best way to do it. And when it says innocent third parties, what we're talking about here is just that, where if you continue to pay rent to the prior landlord, you're entitled to do that unless you've received specific and timely instructions that said you don't need to pay. And as we've pointed out to you again, using our quarterback example, delegations are not allowed where the duties are personal in nature. And again, that makes a lot of sense. This is Dr. David D. Shine for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.